to record, but all right. Hi, everyone. My name is Alyssa. If you've been to a previous webinar, you've probably seen me or heard my voice. You've probably also seen Sarah before. She's a frequent speaker for us, but if you're new here, welcome and thank you for joining us this morning. We're thrilled to have all of you here. And if you're watching the recording, thank you also for your time and attention. I know it was a little tricky with the last minute change, but we appreciate you. Today, we have a wonderful session planned with Sarah Borders, and she will get into a bit of the details of Form 5500 filings, amongst other compliance due dates and upcoming legislation. We encourage active participation for those who are with us live, so feel free to ask questions as we go, and they'll either be addressed as we see them or in the reviewed time at the end for question and answer. And if you have any questions watching the recording, feel free to follow up with Team Benecurve. The email will be provided after. But without further ado, I'll just hand it over to Sarah now. So Sarah, the floor is yours.
Thank you, Alyssa. Thanks everybody for watching today's presentation. We have some important updates and topics, very timely topics to get into that hopefully you will take note of and get ahead of when we're talking about your employee benefits plan. So overall, there is a lot of buzz right now regarding the CAA and fiduciary duties, which is what we'll get into sort of towards the end of today's presentation. But first, I want to go through some hot topics, so to speak, that have been issued, rules and regulations that are issued right now around this time in about the end of June of 2024. So first, we're going to look at the Section 1557 non-discrimination rules that were issued a couple of weeks ago. Then we'll look at the updates to HSA contributions as well as high deductible health plan limits or HDHP limits for 2025, PCORI fees that are coming due by the end of July, as well as 5,500 filings for health and welfare plans that are due by the end of July as well, if your plan is a calendar year plan, meaning it renews or you have a plan year sitting on January 1st, which is probably 80% of employers have a renewal date of January 1st. Then we'll dive into the CAA and fiduciary duties that you need to be paying attention to. We have a really great checklist for employers that sponsor a fully insured plan, medical plan, or a self-funded medical plan, and some steps that you can take today to really outline your fiduciary duties, your process, how to document that, and some things that you need to know in order to be, complying with your fiduciary duties under this rule we call ERISA. And then we'll finalize everything with some takeaways. So first, let's get into the final rule issued for Section 1557. And what is this talking about here? Well, back if we think a few years ago, under the passage of the ACA or Affordable Care Act, which was passed back in 2010 already, that was 14 years ago, there was a section in that piece of sweeping legislation called 1557. That's kind of how we refer to it. And basically, what it is it's the non-discrimination provision that was contained within the ACA. We use this word non-discrimination quite a lot for different rules, and it can refer to not discriminating on the basis of a health plan or a health status, like making somebody ineligible for benefits if they have a pre-existing condition, or we can talk about non-discrimination in the context of not overly favoring those who are considered highly compensated. And in this case, we're talking about prohibiting discrimination on the basis of one of the protected classes. So race, color, national origin, sex, age, or disability in a specified health program or activity, including those programs, those employers too, and those entities that receive federal financial assistance. And I'll kind of get into what this is talking about. This particular rule is enforced by HHS, the Office of Civil Rights. And so usually when we're talking about the way that health plan covers certain things, if there's some sort of mandatory coverage that usually did come as a result of the ACA, it's going to be HHS or CMS that typically enforces that. Usually we also see enforcement bodies like the Department of Labor and the IRS as well when it comes to some of the tax rules. So basically, under Section 1557, under these final rules that were issued back in early May, what it's saying is that covered entities that are subject to 1557, who include health carriers, health insurance carriers, or insurers, TPAs, and even pharmacy benefit managers, or PBMs as we call them. The delivery of services also includes telehealth. So these entities that provide these services, your insurance companies, your third-party administrators, and your PBMs, and sometimes even if you use like a telehealth provider, they are going to be subject to this 1557 rule. This rule basically codifies the Bostock concept that discrimination on the basis of sex, one of the protected classes, includes sexual orientation, gender identity, and pregnancy. So in other words, there was a ruling on that term of sex as to what it means, who is inclusive under that protected class. It's a little more clear with the other protected class, but this has been, a controversial topic, and the Supreme Court did rule on that, and they did include these terms as well. So why we bring that up is because they're using the language of a protected class, and then they can sort of rely upon this ruling by the Supreme Court of the United States that says it does include sexual orientation, gender identity, and pregnancy. So covered entities, those who are subject to this rule, must ensure meaningful access by providing communication in different languages and in ways necessary to make sure that disabled participants can access care. The rule requires that covered entities take reasonable steps to ensure that the use of patient care decision support tools are also not discriminatory. And this can even come into AI, for example. Now, there are exemptions from this rule based on religious freedom and rights. This is expressly allowed under the rules. It does call them out. It's not ambiguous. It calls it out. And basically, there's some thoughts that we have on this if an employer does want to sort of claim religious freedom or their religious rights. But overall, most insurance companies and TPAs are going to have to write their plans anyways to comply with these rules. And so this is going to be something, if an employer wants to make a change or say they're not going to cover something based on their religious rights, then they may have to hire an attorney to get these changed, or at least to have a legal opinion on this type of thing. So what this is saying is that, this isn't expressly required, but they can seek approval from OCR. Also, within this final rule, it contains some notice requirements, notice of non-discrimination, and notice of availability of documents in the 15 most prevalent non-English languages, basically depending on where your company operates and if that county in which you operate has a percentage that is 10% or more of some sort of non-English language speakers. So for example, if we're talking about a county I know of for sure that has 10% or more of non-English speakers, would be Spanish in Bexar County, which is the county where San Antonio sits. And basically, if an employer has their, if they're doing business in that particular county, even if they have, not non-Spanish speaking population, they still have to provide this sentence basically providing and saying they will provide interpretation services in that particular non-English language that is predominant in that county. So luckily enough, the list of those counties is published by CMS and updated periodically. So you can look at it and see, yeah, I live in a county. If you suspect, yeah, we live in a county that has this predominant language, even if maybe we don't have that many employees that use this predominant language, you're still going to want to check that and make sure that your documents contain a sentence or two about providing interpretation services. This really impacts certain employers more than others, but some just kind of have to check the box, and others have to really determine, yeah, we do need to actually get interpretation services if those are asked for. So if you have, a company that has a lot of Spanish speakers or some other language that's predominant in that county, you actually do have them, then you're going to want to look at providing interpretation services should they be requested. So again, turning back to what this rule means for employers beyond these notices. So employers who are in the healthcare field, like who does this actually apply to? And it's kind of strange the way they kind of cast this wide net as to try to get as many employers as possible that would be applicable to this rule. So it's employers who are in the healthcare field and who receive federal funds in the form of Medicaid, Medicare, or TRICARE payments. And if we're talking about a clinic, a hospital, even maybe a doctor's office or the like, a telehealth provider, usually they do accept reimbursements from these different government agencies, which is the federal financial assistance that it keeps talking about. So those who receive federal financial assistance, it would include these types of payments. So if you are in the healthcare field and you're receiving federal funds in the form of these types of reimbursements, then you will have to comply with these rules directly with your employees and your participants under your health plan. Now, fully insured plans, so you just purchase a medical plan from a typical carrier, whether it's Anthem, Blue Cross, Care First, United Healthcare, Aetna, whoever, then most of the time in those situations, the carrier is going to be subject to this law because they also receive federal financial assistance or federal funds, I should say, from the federal government, and again, the form of Medicaid or Medicare reimbursements. So what that means is that the fully insured carrier has to write their plans and their benefits and the way that they cover benefits in order to comply with this law. So there's really not a lot an employer needs to do one way or another. If they didn't want to cover those, then it's probably not likely that the carrier can take out such a provision with a fully insured plan at all. And so that carrier, they are going to be subject to this law, as well as the state insurance law where the plan is written. So there could be even more strict rules around the state insurance law where this carrier does business and where that plan is written from. Now, self-funded plans or level-funded plan sponsors that use a TPA that is also subject to these rules, kind of like the carrier would be. And a lot of TPAs, sometimes you'll see arrangements from fully insured carriers that have what we would call administrative services only models, where essentially the TPA mirrors their plan designs that they help you write, much like they would be for the fully insured market. Instead, they just run claims. They are just the claims payer. They don't, and then they take the funds to pay those claims from the employer themselves. So really, if you're using a TPA that's subject to these rules, they're going to typically write their plans in a way that complies with these 1557 rules because they are subject to them themselves. Now, if a TPA does, in fact, their legal team, for example, feels like the discretion for coverage of these different benefits that could be seen as discriminatory, namely treatment for gender dysphoria, that could be one area where it could be seen as discrimination. If the TPA turns over discretion of the plan design to the self-funded plan sponsor for these particular issues and how they're covered, then the TPA won't be deemed to violate Section 1557. But note that 1557 doesn't require that covered entities, again, these folks here who are subject to this rule directly, it doesn't require that they cover all services for participants with gender dysphoria. That's not exactly what it's saying. However, it's a case-by-case analysis, facts and circumstances based on services that are currently offered under the plan for others. So even if 1557 doesn't apply to the self-funded plan sponsor, the Bostock decision could still apply by way of the sort of employment law side of things. So maybe it's not required for your insurance product to cover gender dysphoria treatments, but it could be seen as a discrimination practice, for employment law purposes. That could be another way that maybe a case is brought or a complaint is filed. So plan sponsors, employer plan sponsors, that's what that means, who want to impose some sort of blanket exclusion for the health services for transgender participants or some other type of exclusion like that, they are at risk of lawsuits and potential enforcement by OCR. Because if you look at this, individuals can just call and complain directly to OCR. They can enter an informal complaint in their website. They can call them, and that could potentially stir some sort of enforcement action. There could be some kind of thing that alerts them, and they contact the employer plan sponsor, and they start looking into things. Certainly ripe with litigation, they could bring lawsuit. And so if there are employers on this call who are particularly concerned about covering these issues or not covering them, especially if you're self-funded, maybe you have a third-party administrator, you have a PBM, pharmacy benefit manager, and you're concerned one way or another about providing this or not providing this or claiming a religious exemption of some sort, really, in this instance, we would strongly encourage you to consult with legal counsel, an ERISA attorney who is well-versed in these rules, and we can always provide recommendations. It's well worth the money to consult and get a legal opinion in a review of your documents. Otherwise, you could find yourself in a lot of hot water, either with a participant or in the course of some sort of investigation that nobody wants to have to deal with. So really, it's not something that an insurance advisor solely can advise on. They can help you strategize and place insurance and cost savings and so forth. But this area really does turn more into the legal advice category and should be dealt with a great attorney, just like you would use an employment law attorney if you had a particularly hairy situation where you want to get your ducks in a row. Same thing here. It's very important, and it's not left to just an insurance advisor to consult with you on. So the final rule takes effect. This particular rule takes effect 60 days from the date that the rule was published. So by my math, that falls on July 5th, 2024, which is next week, as of the recording of this call. And certain other requirements have effective dates at later times, mostly around the notices. So for this rule, litigation is expected. It has already run around through the courts. It's gone through really 3 different presidential administrations, and most of the carriers and the insurers were contemplating these rules already and are really tasked with implementing these rules already to match the requirements. So if you're fully insured, again, there's not really much to do with it. With a self-funded plan, you may want to consult with your TPA to see what is being done about this particular rule. Is there any concern? Is there anything that we need to do? So I think that's a good proactive step. And then also making sure to hand out your summaries of benefits and coverage that do have this non-English language sentence for interpretation services already posted on all of their model notices that you can use. And if you do have employees who maybe speak Spanish or some other predominant language, and those are escaping me now, the other ones that we tend to see quite a bit, they do have sample SBC, summaries of benefits and coverage, in those particular languages. So you're not having to try to get an interpreter to facilitate that. Although you do want to have like a spoken interpretation service if you have a lot of these employees. That's a good practice. Now, I want to turn now to the new limits announced for high deductible health plans and for HSAs themselves and review a bit of these rules. So high deductible health plans, HDHPs, they have to have set out-of-pocket amounts and a minimum deductible that can be no lower than this in order to be considered a qualified high deductible health plan in the first place. So these numbers move up typically each year based on cost of living adjustments. So for 2025, in the right column, we have a little bit of a change to each one of these different limitations. So for self-only coverage, the out-of-pocket maximum can be no more than $8,300, and for family, $16,600. The minimum deductible, the lowest that a deductible can be for a high deductible health plan, is $1,650 for self-only and $3,300 for family. And you got to watch the embedded deductibles here. So what I'm talking about is if you have a high deductible health plan, and this usually comes up with fully self-funded plans, this gets missed. If somebody is enrolled in family coverage and their personal deductible, if they have family deductible maybe of $6,000 or something like that, then they can pay, their benefits can pay no earlier than when they hit that $3,300 individually. So if you had like a $3,000 individual deductible, but a $6,000 family deductible, then that's a problem, because that individual can't have any benefits paid before $3,300 for the family coverage itself. So you got to watch that if you have one of these embedded deductible plans. I just was on a call yesterday where this came up, where an employer missed this for their family coverage, and they had to, really try to go back and fix these issues so that they weren't making people ineligible for their HSA contributions. That's the consequence of what happens if you're not watching the high deductible health plan limits properly. So the HSA itself. So the HSA is a bank account. So we have the high deductible health plan, which is the medical plan that they would be enrolled in. And then they have the HSA, which allows them to pay for qualified medical expenses, either the ones that are, deductible expenses or so forth, out-of-pocket expenses, or on that list of 213D medical expenses that maybe aren't even covered under the health plan itself. So what this is saying is that the HSA contribution limits, the most that an employee or a participant can put into their HSA on a tax-free basis, is $4,300 for self only, meaning they're enrolled in a high deductible health plan just by themselves, or if they're enrolled with anyone else, another dependent, whether it's one dependent or more, the most they can put in their HSA over the course of the calendar year is $8,550. So remember that high deductible health plans can run from calendar year, or they can be off calendar year plans. But HSAs in particular, the limits apply on a calendar year basis, no matter when the health plan renews. If they are age 55 or older, they can put in an extra $1,000 per participant, so to speak. So if they have one spouse who's 65 and one spouse who's 60, they can each put in an extra $1,000 into the HSA. Also, if you are one of the very small percentage of employers that have what we call an accepted benefit HRA or EBRA, then there's an annual contribution limit that moved up to $2,150 for the plan year. Now, moving over to another hot topic, something you need to plan for, may need to plan for, is PCORI fee payments to the IRS. So PCORI fees have been around for a long time now, and they're not going anywhere until 2029. And what an employer who is subject to this rule has to do is to pay the PCORI fee on IRS Form 720 directly to the IRS. This is a quarterly federal excise tax return form. So if you look at this form, or if you're familiar with it, or you're not familiar with it, you'll see that it's a quarterly form, which seems a little strange for payment of an annual fee. But the reason for that is because if you read through it, there's a lot of other taxes that might apply to a business, and they kind of stuck this PCORI fee tax in that form, this existing form. So if you go down to page 2 of the Form 720, we'll talk about Patient-Centered Outcomes Research Institute fee. And then it lists, what your fee is times the number of covered lives. You kind of write that in, and then gives you your total, which you put down at the bottom. So there may be only one section that you actually have to fill out on this Form 720. And then you must mail in payment to the IRS. I don't think you can pay online for this particular fee. So you will want to make sure and go ahead and get that paid prior to July 31st. That's the absolute due date deadline, but you can certainly pay it now if you know the numbers. So it's applicable. The fee that applies is based on when your plan year ends, not when it starts, but when it ends. I don't know why they wrote the rules this way, but this is the way they are. So it's for plan years that ended in 2023. So if you had a plan year that ended in 2023 And that plan year that ended in 2023 was either a self-funded or level-funded plan, or if you had an HRA, but you had a fully insured plan, but you had an HRA or some kind of reimbursement arrangement, then that would be those who have to pay the fee directly to the IRS. If you're just fully insured, you have no HRA, you're not self-funded, and your plan ended 2023, then you do not have to pay the fee. The carrier, the insurance company, pays the fee. So I have a helpful chart that kind of outlines what the fee is based on when your plan year ended. So on this page here, let's say that your plan was a calendar year plan, meaning January 1st renewal, and your plan ended December 31st, 2023. So if you go down to the very bottom there, your filing date is due no later than July 31st, 2024, just a few weeks. And your fee that would apply is $3.22. Now, if you had a non-calendar year plan, maybe your plan renews in July, then your plan is going to end in June 2023, June 31st or June 30th, 2023. So that means your fee is due by July 31st, 2024, same time frame, but it's $3. So again, we're not really sure why they're a little bit different depending on the plan year end date. It may have something to do with when these rules were sort of rolled out, I suspect, but they've been like this for a decade already, and will go on for another several years, 5-6 years. If you click on this particular slide, which I'm sure you'll get copies of these slides, it will take you to the IRS PCORI fee website, and it will show this same table for employers who have to pay this fee, as well as some other FAQs that I think are pretty helpful, pretty straightforward. Now, moving over to the Form 5500 filing, and then we're going to talk about the fiduciary duties. So much like the PCORI fee, this Form 5500 filing is due for employers who had a January 1st calendar year plan. They renew, in other words, on January 1st. So employers, even if you don't have to file right now, employers must file a Form 5500 with the Department of Labor unless you have an exemption. It's due by the last day of the 7th month following the last day of your plan year. So since we're in July, or about to be in July, we're talking about calendar year plans, and the reason for that is because of that due date, the 7th month following the last day of the plan year. So for example, if you have a January 1st renewal, then your plan year ends December 31st. So if you count out 7 months later, we get into July, the end of July. So that is why we're talking about filing for calendar year plans in the middle of July, because this filing is not due right away, like immediately. It's due 7 months later. So you have quite a bit of time to prep for this particular filing. What does that mean? Gathering Schedule A's from your carriers. You might get a Schedule C if you have a self-funded plan, or maybe some other kind of arrangement like an HRA. And you would use that, usually with the help of a vendor, to file this information filing to the Department of Labor's website, their eFast website. If you have a retirement plan, 401k, you probably have a similar, but not the same, filing that you do for your retirement plan. So if you are not otherwise exempt from having to file, you need to make plans and make sure that you stay on top of this. And I'll get into what the exemption actually is. You can request a 2.5 month extension, or up to 2.5 month extension via Form 5558 before the original due date. And many employers are prepared to go ahead and file early. Some need more time because, oops, we didn't know we had to file. The plan may consist of one single ERISA plan, like just life insurance or just medical insurance, although it's usually the life insurance that gets the highest participation because everybody gets it automatically. Or you may have what is called a wrap document, a wraparound document that combines all of the ERISA provided benefits such as medical, dental, vision, life, disability, health FSA, HRA, on and on, these types of benefits. This document called a wrap document wraps around it and makes one single ERISA plan, one big ERISA plan. an umbrella document. And so if you have a wrap document in place, which we would always advise that you get one, and you can ask Benacurve if you need help in getting a wrap document in place, then there needs to be one single 5500 filed for all of those component benefit plans together. It makes it just a lot easier. In some ways, it's a little bit cheaper, and it just makes it more organized than having to file one for medical, one for dental, one for life. And so you do typically see wrapped benefits filed into one single ERISA plan. Now, if you are very late, or maybe 1 year or 10 years late in filing this particular 5500, which happens all the time, then there is a delinquent filer voluntary compliance program that is necessary, or can be necessary or used for late filers or people that didn't file, to avoid substantial penalties. So if you get caught by the Department of Labor and you haven't done this, then they can apply up to, what is it now? It's like $1,500 per day for late filings. So if you haven't filed in 6 years and you start adding up 1,100 or 1,500, excuse me for not remembering exactly what it is, it's something like $1,500 per day that is late. And you compound that over, 5 years, 4 years, 3 years, 10 years, that is a substantial penalty. And so the delinquent filer program caps the liability at no more than $4,000 total if they kind of come and get all their ducks in a row. We would absolutely recommend that if you feel like, oh my goodness, we haven't filed this in years, we're well over 100 plan participants, or have been for many years, we don't have any other exemptions, so we need to kind of get current. This is the way to do it. Otherwise, if you don't do it and you get caught, there can be these really substantial penalties imposed on you. Following the 5500 filing is a notice of what was kind of contained in a summary format in the filing itself that has to be sent to plan participants. It's called a SAR, Summary Annual Report. And this one is typically, if you use a vendor, this one is usually kind of populated by the vendor for the employer then to send out to their employees and their COBRA participants. So who might be exempt from having to file the 5500? So if you're not subject to ERISA at all, then you don't have to file the Form 5500. So who is exempt? Really only small subset of employers: governmental plans, non-federal governmental plans, church plans, or Indian tribal plans. And this, even within those, is a very narrow definition. So if you are maybe a school district or community hospital or something like I'm trying to think of another common example, would be like a county or something like that, then you probably are not an ERISA plan. But if maybe you're affiliated with the church or affiliated with some sort of Native American plan or nation or something like that, then it's a little bit more hard to tell, because you can't just be sort of affiliated with them. There has to be a true exemption present here. So if you're falling or think you may fall into one of these buckets, especially the church or Indian tribal plans, again, you may want to consult with an attorney to really, really pin down, are we not subject to ERISA, or are we? Now, if you're a small employer, one who is unfunded, meaning you don't pay benefits out of a trust, fully insured, or a combination of both, fully insured and unfunded, with less than 100 participants as of the first day of your plan year, then you do not have to file the Form 5500. So let me give you an example. A plan has 99 participants as of January 1st, 2023, the first day of their plan year. That was their January 1st plan year, but went up to 105 on January 2nd, the very next day. Then they would not have to file the Form 5500 as of July 31st, 2024. And remember that wrap plans includes all of the component plans under a single ERISA plan. So you must watch each component plan's participant count. So why we say this is, a lot of times people are only looking at the medical plan, the enrollment on the medical plan. Participants means employees and COBRA participants. It does not mean dependents. So if you're thinking, well, our medical plan only has 90 people enrolled, but you fail to look at the component plans like a employer paid life insurance plan or employer paid disability plan where everybody gets it. You may well be over 100 and have missed many years of filing because you weren't thinking about the employer, 100% employer provided benefit itself. So you really have to look at the plan with the highest participation or enrollment and determine, were we over 100 or not as of the first day of the plan year. So hopefully that helps you understand these exemptions and really to pin down if they apply or do not. If you have questions about this, please feel free to reach out to Benacurve and we can get a little bit more clear on, does this apply or not? Do we need to have a call? Do we need to look at some records and so forth? And how far back has this been missed? So the summary annual report that I mentioned, the plan administrator has to distribute the SAR to participants. Again, those are employees and COBRA participants and retirees, if you cover retirees, within 9 months of the end of the plan year. And there is a model notice available, or typically your vendor will give you the SAR itself. If an extension was filed for filing Form 5500, the SAR must be sent within 2 months after the close of this period for which the extension was granted. So basically what that's saying is within 2 months after the 5500 was filed. If it went a little longer because of an extension, you'd want to get it out at least within 2 months, if not a lot sooner than that. So who's exempt from the SAR? A totally unfunded, not to be confused with self-funded, a totally unfunded means a self-insured plan that pays benefits out of a general operating account, not out of a trust. So you can be self-funded and unfunded, meaning you pay benefits out of a general operating account, regardless of size, and even if they must file a 5500. Also, if you didn't file a 5500, there's no SAR required. However, large 100 plus fully insured plans must give a SAR even if unfunded. So because, again, there's usually a wrap in place, you're going to have some fully insured plans that would be included in the SAR. So watch that. Make sure that you're also thinking about and including the fully insured products that are offered under the wrap. Now, let's spend the rest of the time today talking about health plan fiduciary duties. And this does all somewhat tie into the 5500 and sort of the reasonableness of the costs of coverage, et cetera, because all of this fiduciary duty that you have as the employer who makes decisions about the operations of your plan, you make decisions about carriers that you go with, you look at RFPs and quotes, that's you. Fiduciary is not somebody you're named it and that makes you fiduciary. No, it's the actions that you take. It's the responsibilities that you have. And you're sort of brought into fiduciary status by the very nature of the job duties that you have with regard to your health plan. So again, turning over to retirement plan aspects, probably you're a fiduciary of your retirement plan because you're involved with decisions regarding the retirement plan and actions and activities that go on with who you select, et cetera. Same thing over on the health and welfare side. You have a fiduciary duty. Again, whether you know it or not, you are a fiduciary. So what is highlighting this? Kind of like the ACA highlighted a lot of things that we weren't really thinking about prior to it. The CAA, the Consolidated Appropriations Act of 2021, has really put the spotlight on this idea of being a fiduciary and what all that encompasses. So it has increased enforcement of health and welfare plans and has led to additional litigation, especially one that really took kind of the news cycle by storm. We're still watching it, is the recently filed Johnson & Johnson class action lawsuit. And there's other cases that are pending like it that demonstrate, that show the importance for employers to consider their fiduciary duties and best practices as their role as an employer plan sponsor, a health plan sponsor. You're sponsoring a plan. And so I want to outline what that actually looks like in practice. Like, what does it mean for us to comply with our fiduciary duties? And I'll go through, I have sort of a takeaway slide as well, but I thought it would be good that we provide you with a fiduciary best practice checklist for the type of major medical plan that you sponsor, whether it's fully insured. Again, you just buy a plan from a carrier and you pay premiums and they pay benefits, how they're outlined, and that's kind of it. Or if you're self-funded or level funded, where you have way more control over the claims spend, you can see your data, you hire a pharmacy benefit manager, you hire a TPA to run claims and to analyze claims. So the different types of funding arrangements are going to dictate what your fiduciary duties and processes actually look like. So first and foremost, if you are a fiduciary, which you would be if probably you're on this call, you want to consider obtaining fiduciary liability insurance. So I don't think this is very expensive, and it can be something that you add on to your sort of other insurances that you have on the property and casualty side, where you add a rider of some sort to protect those who are considered fiduciaries from these types of lawsuits and so forth, or other types of failures that can come as a result. So fully insured or self-funded, yeah, you may want to consider adding the fiduciary liability insurance. Ensure that your plan documents are up to date, that they're reviewed, that they're in good shape. So what does a plan document mean? That can be your carrier booklets plus your wrap document. And we would really, really encourage you or recommend strongly that you look at getting an ERISA wrap document in place, because your carrier certificates of coverage and booklets, those policy documents, are not sufficient to be considered a plan document as described under ERISA. The wrap document can supplement the missing information and make it altogether a fully compliant plan document. Either way, though, you have to review these things. You have to know what they say. You have to know what eligibility says. You have to really run the plan in accordance with what's written down in your plan documents. Far too many employers have no idea what their plan documents say. They don't even have a plan document. So again, like a retirement plan, that has an SPD and a plan document. You got to have one for health and welfare as well. You want to obtain and review all of your disclosures, these compensation disclosures, from your covered service providers. So this could be your broker, your insurance advisor. They would be giving you the compensation disclosure that outlines what they're being compensated and what they're doing for their compensation. Mostly, such as Benecurve does a lot for that compensation. And whereas another advisor may do far less, they don't assist with a lot of things. So just because something is maybe a little bit more expensive or less expensive does not mean better, or does not mean that you're getting the value that you could be from someone that maybe charges a little bit more in compensations, just for example, but they provide a whole other world of services and value to you that can be demonstrated and accounted for in the value. Like, yes, we're paying this amount, but this is what we're getting for it. So things like that need to be asked for, obtained, and vetted every year as a fiduciary. So you want to request and keep also the mental health parity, non-quantitative treatment limitations comparative analysis in the file. So I've talked about this in the past. Basically, you will get from your fully insured carrier this thing called a MAPIA, Mental Health Parity Addiction Equity Act, non-quantitative treatment limitation comparative analysis. Sometimes we shorten that to NQTL analysis, and just keep it on file. That's about all you can do with a fully insured plan. Create a process for deciding employee eligibility matters. So do you have a process in place for qualifying life events and qualified medical child support orders and all these other things that come up throughout the year, where you need to outline who's eligible for our benefits? When do they terminate if they go on leave and they no longer qualify for FMLA or some sort of state or local leave? So eligibility matters are oftentimes not really paid much attention to. You need to make sure that the people that are eligible under your plan are the ones that are allowed to participate, and that they're taken off on time and offered COBRA if they have a COBRA qualifying event. Any personal relationships between company leadership and service providers should be vetted for conflicts of interest. So if your owner is, the brother-in-law of the owner of a TPA, that could be a conflict of interest. Or if they're getting some compensation as a result of working with a particular carrier. We don't usually see that, but those types of conflicts of interest should be vetted and really dealt with and ended, because they can come back in the course of a Department of Labor investigation. Monitoring service providers to ensure that they are doing what they agreed to do when you retain them. So if they promised all this help with compliance, are they following through? Are you getting what you paid for? And work to address and keep records of participant complaints or claims issues. You want to have these paper trails. And so you really want to outline all of these things in a process. Like you take this checklist and you document that you went through these things year after year. Now, if you are self-funded or level funded, it gets a little more complicated. The areas that are italicized are the same as this. So we've added a few here. So I'm not going to go back through the italicized pieces, but I'm going to talk a little bit more about if you're self-funded, there's additional things that you might want to consider. This checklist is not some sort of model notice or something that was issued by the Department of Labor. It's just as a result of our experience, namely one of the consultants that we work with is a prior Department of Labor investigator who did investigate health and welfare and retirement plans for many years. And she is an ERISA attorney, and she and BCS actually came together to come up with a best practice list so that you could go through them line by line. So if you're self-funded, then you might want to consider at this point chartering a health and welfare fiduciary committee. So you have a committee that discusses claims and appeals. Maybe you discuss the plans, you discuss the costs of the plan, you discuss different service providers, and you have minutes. You have meeting minutes, you have documentation that these things were discussed. Larger companies that have self-funded plans almost always have a fiduciary committee or a health plan committee. Then doing all the other things we just talked about, you also want to review your service provider contracts, specifically identifying any clauses having to do with access to your claims data and whether the service provider agrees to certain reporting requirements. So if you're using a TPA and they have some sort of language that restricts your data they're not going to give you your data, that's a problem under the CAA. Or maybe they say in their service agreement that they're going to submit reports to CMS for RxDC reporting or air ambulance reporting whenever that becomes due, and they're not doing it, then you want to question that and push back and maybe consider using a different TPA if they're not helping with compliance requirements. Set up a process to monitor health plan fees. Consider an RFP process at specific intervals, of course, like annually. You want to vet these fees. Are these exorbitant? What are these fees? What are we getting for these fees? There's all kind of fees tacked in with per employee per month fees, which can sometimes be very necessary for, again, what the value you're getting. But if there's some kind of fee and you have no idea what it's for, or it doesn't seem like it can be reconciled, then you might want to question that fee and then document what was discussed about it. And again, consider negotiations, getting it removed, or moving service providers, as taxing as that can be. Request the MAPIA non-quantitative treatment limitations comparative analysis. Again, that is provided by your claims payer, your TPA. So if you're using Imagine 360 or UMR or a Blue Cross Blue Shield ASO model where you're using them to pay your claims. It's not a fully insured plan, but they run it as if you were, and you pay the claims. You want to also request the mental health parity NQTL analysis, just like you would for the fully insured product. And then also the same things that applied in the fully insured context would apply here, vetting those conflicts of interest, monitoring service providers, working to keep records of participant complaints and any eligibility matters, same thing. So general employer plan sponsor takeaways, specifically with regard to your fiduciary duty and why it's being highlighted under the CAA and why even 5500 can play a part in this. Because if you look at a 5500, again, back to the filings that are submitted to the Department of Labor, they have compensation that are paid in the form of usually commissions or sometimes fees that are paid to advisors are listed on the 5500 filings. They can't always tell the whole story, and they can be sort of confusing in the way they're reported. So I would not rely only on a 5500 filing to see how much someone's being paid. I would instead ask for the compensation disclosure that's required for them to give you. So, and you as a fiduciary need to ask for it. If you didn't get it, you need to request it. That's your responsibility to request it, but most advisors are giving it proactively. Okay, so some takeaways for you. The conversation around pharmacy costs, PBM, pharmacy benefit managers, the costs around this, and how appropriate they are will continue because of this Johnson & Johnson lawsuit, because the costs of these drugs, and if they're not properly scrutinized, can really cause the entire plan to be a lot more expensive than it should be, because there's paying more than the fair market value or the amount you would pay going just to a pharmacy and paying, like a retail amount. I think that's what sparked this particular Johnson & Johnson lawsuit. Employers should really educate themselves on the role of a PBM with the help of their advisor, their insurance advisor, of course, and how that affects the health plan. And then employers have to understand that they are just as much a fiduciary of their health plan as they are a fiduciary of their retirement plan. You have to think of it that way. Compliance must be buttoned up. So this is compliance with every area. Your ACA forms are done. Your COBRA is running smoothly. Your non-discrimination testing is properly run each year. Your HIPAA policies and procedures are in line. So you have to be in compliance as a fiduciary, just because they can be ripe for litigation. They're just fodder for lawsuits and complaints. So all of the areas of compliance need to be buttoned up, and that's something that we can help with. Participant complaints about things should be addressed sufficiently, timely, quickly, and documented. The conversation around plan design should involve more than just merely cost. It does need to consider disruption. Are things covered properly? Are we causing people to not be able to access care? All of these things need to be considered with who you work with. It's everything about who you work with. And employers really have to take a much more predominant role and not just go on default like, oh, our broker handles that. You have to be involved in the conversation. You have to be involved in the process. You have to be making sure that you are in compliance, because it is not just the carrier or the broker's responsibility. Absolutely not. That conversation needs to change. That expectation needs to change. And so overall, just to quickly recap the rest of the items, beyond fiduciary duties and so forth, and we'll provide this list for you and you can take that and use it, please do. But you also want to make sure that you're really examining the 5500 rules, you're paying your PCORI fees on time, you're filing your Form 5500s in time based on when your plan year begins, and making sure that, does an exception actually apply or not. And then also looking at your HSA and HDHP limits and your communications with your employees, making sure that that is all outlined and clear and up to date. So a lot to cover today, but hopefully this begins your thinking with regard to your fiduciary duty and just overall compliance. So that's all I have for today. Alyssa, are there any questions? If not, I can just turn it back over to you.
Yeah, I don't see any right now. I'll give maybe people a second to type any, but always feel free to follow up with us afterwards, because I know questions kind of come down the line too after we process all this information. But what a great webinar today, Sarah. Thank you so much for your time. And all of this is so relevant, and we have the resources with you and with BeneCurve to make sure that everyone is staying compliant throughout the entirety of the plan year. So thank you for your time. And after this webinar, you all will receive a recording of it and an invite to our webinar next month with Tommy Lipner, of Regional Vice President of Pareto Health, who will be getting into a great discussion with our CEO, Jonathan Anders, about captives. We always encourage participation and promote an ongoing learning environment for clients and prospects. in and around employee benefits trends. So I hope to see all of you there in July. And with that being said, I will just wish everyone a great rest of their day and week. And thank you again, Sarah. Have a nice day.
Thank you.
Bye.